and I no longer wish to be called by my given Christian name.
(26 CR 571). Are you Christopher Roberts?
I would like to make a statement, Your Honor.
I just want to know if you're Christopher Roberts.
I wish not to be. I'm a free living man that was sold by color of law at birth, and I do not wish to contract with the state of Israel, the Freemasonic Order, or the Catholic Church.
Well, I'm not going to require you to do that.
Yeah, well, you kind of are by forcing me to say that I am the person that you named me at birth.
Okay, well, Mr. Hogue, we have a filing of complaint and information. Do you want me to read that to the defendant on 2 counts?
We waive formal advisement. I think in the interest of, I think we would just be requesting a status date on this case, the very next available date.
Defendant's bond is set at $500,000, remains that, cash or surety. The defense has waived reading of the complaint and information. And so do you demand a prelim at this moment, Mr. Hogue?
We have filed a written preliminary hearing demand into this matter. We were not waiving a preliminary hearing or anything. I just think for scheduling purposes, it would be easier to handle this case in front of Judge Schoeneman.
Your client's entitled to have a preliminary hearing within 35 days of his incarceration. So that's June 17th is the date, looks like. Do you want the prelim set within 35 days?
Yes.
May I have a date, please? So that's probably by July 16th. At 1:30.
So if we're setting it for prelim, we could do July 16th. We already have a couple that afternoon.
1:30? 2:30?
Yeah, we could do 1:30.
Court sets the matter over for preliminary hearing, July 16th at 1:30.
Can I ask a question?
You can ask your attorney a question when we're finished with this hearing. Anything else, Mr. Hogue?
No, Mr. Roberts, I'll call you.
Thank you. All right, case is concluded. Mr. Roberts, you're back to the custody of the sheriff.
All right, let's go over to the Rio Grande County Jail.
State your name. Enki.
All right, state your name again. I couldn't hear you.
I was sold at birth to the state of Israel by my birth certificate. And I no longer wish to be called by my given Christian name. I would like to be referred to as Enki.
Okay, Mr. Enki, let me ask you this. I'll refer to you as Mr. Enki if that's how you want to be referred to. Sorry, my lights go out here. Mr. Enki, on your birth certificate and your given name, I know you don't want to be referred to that. What's your last name on your birth certificate?
On that slavery document, it's Roberts.
Okay, thank you. Appreciate that. So I have Mr. Enki, who goes by Mr. Enki, or AKA Christopher Roberts, appearing virtually today via WebEx from the Rio Grande County Jail. So Mr. Enki online, I have Ms. Kearns with the Public Defender's Office and Ms. Stewart, she's with the District Attorney's Office. Ms. Kearns, did you have a conflict in that case as well?
We did, Judge, and Mr. Enki has Riley Selleck already appointed as ADC on another matter, so I didn't get a chance to reach out to him, but.
Okay.
I only have one thing to say, Your Honor. Are you aware of the articles of the Constitution 241 and 242?
So I'm very aware of the Articles of Constitution, Mr. Enki, but what I'm going to do today, because it's not relevant for today's proceedings, so what I'm going to tell you is this, okay? A couple things I'm going to do today, all right? So I just need you to listen to me. You don't have to say anything because you have a right to remain silent. It's perfectly fine. I respect that right. I just have to make sure that you understand these proceedings and make sure that I advise you of the rights that you have, okay? So you do have a right to remain silent. Anything you say can be used against you. You have a right to an attorney. If you cannot afford an attorney, one can be appointed for you through the public defender's office. You have a right to a jury trial in this matter, and a right to require the state to prove beyond a reasonable doubt the allegations against you. At that trial, you have the right to cross-examine and confront any witnesses, as well as present evidence in your own behalf. You do have the right to a speedy trial, which means you have a right to a trial within 6 months from the time that you enter a not guilty plea. Any plea you do enter needs to be free and voluntary and not the result of undue duress or coercion. You would have the right to file an appeal to a higher court if you're found guilty, okay? The charge against you, Mr. Enki, at this point is a Class 1 misdemeanor, which carries a maximum penalty of up to 364 days in the county jail. Now, I'm going to issue a protection order in this case. These are mandatory protection orders issued in all criminal cases. That protection order states that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts you've alleged to have committed, nor shall you have... Now, hold on. And in addition to that, any bond that I issue today, one of the conditions of your bond is your compliance with the terms and conditions of that protection order. If you were to not follow the conditions of that protection order, you could be subject to additional misdemeanor or felony charges, be held in contempt of court, or have your bond revoked, okay? Now, Mr. Enki, one of the purposes of today's hearings is to have a bond hearing. So you can address the court if you would like to address the court in regards to your bond, but I want to remind you that you have that right to remain silent. Anything you say could be used against you, so don't talk about the facts of the case, okay? We have law enforcement on these proceedings when we record these proceedings, so please keep that in mind. Again, you don't have to say anything at all if you don't want to. So what my process typically in these situations is I get the state's position first on what they are requesting for bond, and then I give you the opportunity to address the court, okay? All right, with that, Ms. Stewart, what's the state's position on bond?
Your Honor, at this time, we would ask that the bond just be the scheduled amount of the $1,000 cash or surety. I will let Mr. Enki know that based on the affidavit that our office will be looking at whether or not this is self-defense, but I want to go ahead and get the bond in place just in case the video shows something different.
All right, thank you, Ms. Stewart. All right, Mr. Enki, was there anything you wanted this court to be aware of in setting bond today?
They have put my assailant in the same cell block, back into the same cell block as me. And the only other thing is that I would like everyone to either know, or if they do not know, I want them to be aware that the state cannot be a victim.
All right, thank you, sir. All right, with that, this is what I'm going to do, Mr. Enki, is I'm going to keep bond at the scheduled amount, which is a Class 1 misdemeanor. It's $1,000 cash or surety. I will give you the cash option for that, which is $100 cash if you would like to post that bond. I'm going to set the matter back over in front of Judge Stinger, who is the Rio Grande County judge. Right, you'll be back. I'm sorry, sir.
I said I would like these charges dismissed, as the state cannot be a victim, as you well know.
I understand that's what you're requesting. Please understand that I am not the presiding judge in this case, okay? So I'm going to set this matter back over in front of Judge Stinger. I'll set that over for that July 27th date at 1:30 p.m. That's going to be your next court date. That's for what's called the return filing of charges. And that's the deadline that you have, Ms. Stewart, to file charges against Mr. Enki.
Yes, Your Honor, thank you.
All right, anything further, Ms. Stewart?
No, Your Honor, thank you.
All right, thank you, Mr. Enki. Have a good day, sir.
You guys all have a good day.